19 and 35. These are the review petitions in which I appear.
19,
901.2, 18, 19 and 35. Let me just set out who the parties are.
data arguments. What is the volume and what's the text?
Mine is that volume 1.2, page 242 is where my written submission starts.
1.2,
1.2, page 242.
page 246.
242, printed in red. And PDF, I think it's also 242.
1.2.
Please, it's volume 1.2, PDF 242, and it's also printed in red 242. Milords has it?
That's right.
Please. So these are the review petition numbers. Kindly make a note of the parties from my last.
Those are gap of the
The Pandaram family, which is the foster family of Deity itself. So which is why I'll have something to say on the issue.
Yes.
I am also representing Chetana, which is a women's organization that stands in support of the temple's tradition. I also represent an all India organization of Ayyappa temples, which is writ petition 39642. I am also representing the Shirur Mutt in this matter, which is IN number 18313 of 2020. I also represent the Tantri of the Padmanabha Swami temple, who has a direct say with respect to the practice of the Sabarimala temple, and that is 18326, and the Chilkur Balaji temple 11778 of 2020.
that you have mentioned almost in para one of your opening.
I have. The other three IAs I have not mentioned with respect to Shirur Mutt, therefore I'm pointing this out. Fair disclosure, these three IAs for intervention were dismissed by the previous bench on 10th of February 2020, but my submissions will be common. Because I will primarily focus on the relationship between 25 and 26, that vexed question. I'd only request my lords to kindly come to page number 251, para 6 of my written submission, in terms of the questions that I wish to canvass.
251?
251 printed, para number 6.
Yes.
My lords has it, my lady has it. Please. My lord Justice Bakshi has it. Please. It is humbly submitted that in order to address the above questions, which is the questions framed for reference, and additional questions, a holistic understanding of part 3 is called for, of which articles 25 and 26 form part. Since part 3 of the Constitution deals with fundamental rights, the following foundational questions must be asked. I only request my lords to kindly take a look at the questions. Who do these rights inhere in? Who are they available against or in relation to? What is the nature of rights? What are their limits? And who enforces these rights? One question that my lady had actually asked, which I think is central to the question of relationship between 25 and 26. If 26 is about denomination, under which provision do non-denominational institutions trace their rights? That was the central question that is asked. In my humble view, all of this turns on the history of articles 25 and 26. And what I've done for my lord's consumption is, my lord would find this spiral folder on everybody's bench. My lord, kindly take a look at this. This contains the history of 25 and 26 in its entirety. And that will also explain the relationship between 25.2 and 25.1. I'd only request my lords to kindly take a look at this document, because this, in my humble submission, will be the nub of the matter, the core issue here, because that seems to be the question that has been repetitively coming from the bench. So I request my lords to kindly mark paragraphs 1 until 30, rather 32, that is the first 22 pages of this note are only extracts of the entire history of articles 25 and 26, including the transition of the language as to how it emerged. I request my lords to kindly bear with me as I walk my lords through this history, because this should answer more or less most of the questions put in relation to the following questions. What is the relationship between 25.2 and 26? Question number 1. What is the meaning of a denominational institution? And is religious denomination different from a religious institution? What is the distinction? I want to show all of that. My lords may kindly have page number 2 of this spiral folder. I'll only focus on this and nothing else for now. My lord Justice Amanullah has this. Please. So my lords, just kindly give me some leeway to walk my lords through this, because this should answer everything. Prior to the adoption of the Objectives Resolution on 22nd of January 1947, there were 2 preliminary notes on fundamental rights which shed light on the predecessors to Articles 25 and 26. One is Mr. B.N. Rao's note, who was the constitutional advisor, who broadly enumerates the kind of fundamental rights. Kindly see the first prototype of Article 25 under Mr. K.T. Shah's note, which is extracted in para 3. My lord sees that. So in the draft clauses presented by Mr. K.T. Shah in his preliminary note of 23rd of December 1946, clause 15 reads as under. Every person living in the Union of India and is hereby guaranteed the right to freedom of conscience, which includes freedom of belief, worship, or profession of any religion, faith, or doctrine, as well as the negation of such belief, subject to public morality and order, subject to such laws as ensure the maintenance of public peace, tranquility, and good relations amongst the various sects and communities in the country. After the adoption of the objectives resolution, my lords, 5 subcommittees are appointed which deal with fundamental rights. Now kindly come to the next page, which shows who are the committee members with respect to the Fundamental Rights Committee. That is on the next page. Now I request my lords to kindly read para 5, because this will show that 25.2 as it exists was always meant to be a proviso to 25.1. That is, it was never intended to affect 26 whatsoever, is an argument that has been made through interpretational route. I'm showing that historically this has been the case, which is, I'm leaving the consequences for my lords to judge. I'm only saying history of these provisions shows that 25.2 was meant as a limitation only on 25.1, because which is why it speaks of nothing in this article, and there's a reason for it. Kindly come to para number 5 at page number 3. All citizens are equally entitled to freedom of conscience and to the right freely to profess and practice religion in a manner compatible with public order, morality, or health. Please see what it says next. Provided that the economic, financial, or political activities associated with religious worship shall not be deemed to be included in the right to profess or practice religion. Therefore, it was meant to be a proviso. Kindly note, in my humble submission, the better part of these provisions and their amendments came from Kulapati K. M. Munshi, who can rightly take credit for crafting the language the way it is. So this is the proviso. Now, I request my lords to kindly take a look at the proviso for a moment. In the second line of the proviso, it says religious worship. My lord sees that. That subsequently becomes religious practice, because they decided that worship was too narrow and this should cover practice as well. And that was the discussion this was not even in the Constituent Assembly. This was in the committees before it went to the Assembly. Now, my lords may come to the next page. Para number 6 is Mr. Harnam Singh's draft. And my lords would see clauses 5 and 7 are the clauses introduced by him, which are more or less similar to the original draft. Now I request my lords to kindly come to para 7 at page number 4. And I request my lords to kindly make a note of these points for one good reason. Courts have been grappling since 1954 on the question of how do we interpret denomination. And Shirurmat has given the impression that denomination is something exalted, which is distinct and unique. Dr. Ambedkar and Dr. K. Munshi were not of this view, because 26 was meant to be a specific application of 19(1)(c) in a religious context, which is freedom of association is provided in 19(1)(c), and the limitations on freedom of association are in 19(4). 26 was meant to be a freedom to religiously associate. So in that sense, 26 is a specific manifestation of 19(1)(c) in a religious context. And therefore, denomination was never used in the context of giving it a separate character altogether. And I'll show my lords. Please, sir. My lords had a question. Please. And this will emanate from the clauses proposed by Dr. Ambedkar on 24th of March 1947, page 4, para 7. What I'm trying to do through this endeavor is to show we need not go down the path of interpretation and get caught in the question of what is a denomination, when those questions have already been answered by the history of the provision. I've gone through all the written submissions. In my humble view, this portion or this history was not there, and therefore I thought this could put the matter to bed. Now kindly see this. My lords would see 14, 15 onwards. Can I just read this for the court's benefit? These are the proposals under Dr. Ambedkar's note of 24th of March 1947, under the heading Fundamental Rights of Citizens. I've given the relevant page numbers from the existing compilation of the court. The state shall guarantee to every Indian citizen liberty of conscience and the free exercise of his religion, including the right to profess, to preach, and to convert within limits compatible with public order and morality. This is more or less Article 25. Now kindly see 18 onwards. Clause 18, 19, and 20 shed abundant light on the predecessor to Article 26. Persons following a religion shall be guaranteed freedom of association and shall have, if they so desire, the right to call upon the state to pass legislation in terms approved by them, making them into a body corporate. Can I request my lords to turn the leaf and kindly see clauses 19 and 20? Every religious association shall be free to regulate and administer its affairs within the limits of the laws applicable to all. Religious associations shall be entitled to levy on their members, contributions on their members. This is not relevant. 18 and 19 show that denomination was preceded by religious association, which is why in the debates, my lords would not find a specific discussion on what would amount to a denomination. Because a denomination is always meant to be understood as a collective expression of individual rights. Therefore, every body of people which comes together under a common belief to establish an institution will be entitled to rights under Article 26. So here's one question for my lords to consider. If 26 had not been there, what would have happened? It would have been still part of 25(1), except that they decided to pull it out of 25(1) and give it a separate character for one good reason. Because Part 3 can be applied to 25, but Part 3 cannot be applied to 26, and that is conspicuous in the absence of the language itself. Therefore, to ensure that collective rights or denominational rights or associational rights are not fettered by the limitations of 25(1), the bundle of rights within 25(1) were plugged out and carved out as Article 26, and there is a discussion to this effect. Therefore, the submission before my lords is, there is a very conscious reason for keeping 26 as a separate right as opposed to 25(1). There is a conscious reason for making rights under 25(1) subject to Part 3, but not 26. And the word denomination does not have a definition in the Constitution because it was always meant to be understood as a collective or an association. Now, my lords may kindly come to the paragraph under the indented paragraph at page number 5, just about para 8, which is my statement. I request my lords to kindly make a note of this. Draft clauses 18 to 20 of Dr. Ambedkar's draft contain the germ of Article 26, which indicates that denomination has been referred to as religious association and has not been subjected to any higher standard as required by Shirur Mat. Then my lords may come to para number 8. Again, K.M. Munshi on 26th of March 1947 puts forth before the subcommittee of fundamental rights Article 6. I request my lords to make a note of Article Roman 6 because it is this Article Roman 6 that becomes Article 13-14 at some point, Article 19-20 at some point, Article 20-21 at some point, and then becomes 25-26. That is the journey of this entire thing. Now kindly take a look at the language here. This will show that 25(2) is only subject to 25(1) once more. Rather, it applies only to 25(1). All persons are equally entitled to freedom of conscience and the right freely to profess and practice religion in a manner compatible with public order, morality, or health. The right to profess and practice religion shall not include economic, financial, or political activities associated with religious worship. My lord sees that. Then, so what was given as a proviso is then fused into a composite provision. Then my lords may come to the next page. At para number 9 on page number 6 is the revised version of Article 26 introduced as part of Sri B.N. Rao's draft. Please see what it says. Every religious denomination shall have the right to manage its own affairs in matters of religion and to own, acquire, and administer property, immovable and movable, and to establish and maintain institutions for religious or charitable purposes consistently with the rights guaranteed in this Constitution. This becomes later in accordance with law under 26D. Now, my lords would see what is missing here is, my lords would see that public order and morality is completely missing here in this particular draft. That gets introduced later. So I'll show that. Now, my lords may come to para number 10 at page number 6. This is the combined draft of Article 6, which is the future Articles 25 and 26, as adopted on the 26th of March 1947. My lords would see that clause 1 of Article 6 is proto-Article 25, or the predecessor to Article 25, rather 25(1). Then my lords would see that the explanation with respect to Kripans has already come. And please see, 25(2) was then inserted as an explanation to clause 1. Therefore, it was always meant to be limited in its application. I'm just reiterating the point over and over again, that it never severs the umbilical cord that connects 25 and 25(2) throughout its entire history. It becomes an explanation, it becomes a proviso, then it becomes 25(2). That's the only difference. Then kindly see this. This is the new clause that Sri B.N. Rao recommends at the bottom of Article 26. My lords could see, kindly see the bottom of page number 6. Every religious denomination shall have the right to manage its own affairs in matters of religion, so on and so forth. My lords has already seen that. Now I request my lords to come to the next page.
where it says consistently with the rights guaranteed in this Constitution.
And then my lady would see how that language gradually changes.
That is, it becomes diluted.
I'm so grateful. It becomes diluted, and not just that. Wherever it refers to clause 6, that is clause 1 of Article 6, which is 25(1), initially it kept saying subject to the rights in this chapter. That chapter becomes part later because everything is reworded. So chapter becomes part, and I'll show all of those changes as well. Kindly come to the next page, para number 11 at page number 7. May not see that.
Yes.
May not, this is Madhavan, has it?
Yes.
Please.
On one.
I'm so grateful. On 27th of March 1947, the following portions were added to clause 6. Now begins the Irish influence. So 44 to degree 1 and 44 to degree 5. Degree 1 speaks of 25(1), degree 5 is 26. So denominational rights come from Article 44, Clause 2, degree 5 of the Irish Constitution as it existed then. Article 44, subclause 2 and degree 1 was the equivalent of 25(1). Now kindly take a look at this. My lady may come to, in fact my lady can, my lords can perhaps ignore para 11. Kindly come to para 12 on the next page. On 29th of March 1947, this is proposed. The provision relating to freedom of conscience and the right freely to profess and practice religion was amended so as to include at the end of the words and with other rights guaranteed by this Constitution, which becomes a reference to subject to part 3. Then kindly see para 13. On 30th of March 1947, the following explanation was sought to be added. To clause relating to freedom of conscience, add the following explanation. This is explanation 3. No person shall refuse the performance of civil obligations or duties on the ground. Gradually, this explanation is done away with at a later point of time. My lady may then come to para number 14 at the bottom of page number 8. 3rd of April 1947 is an important milestone because on that date, the draft report of the subcommittee of the fundamental rights is shared with the advisory committee. Please see what are clauses 16 and 17 there. 16 says, all persons are equally entitled to freedom of conscience and right freely to profess and practice religion, subject to public order, morality and health, and to other provisions of this chapter. This chapter becomes part later. Kindly come to the next page. And once again, my lady would see 25(2) is an explanation 2 to Article 16, draft Article 16. The right to profess and practice shall not include any economic so on and so forth. My lords is aware of this. 17 is 26. Then my lords could come to para number 15, where we basically see that Alladi Krishnaswamy Iyer, as part of his notes on this draft, cites the Jehovah Witness judgment. No wonder it features later in subsequent judgments. Specifically saying, how do we deal with this particular situation? Because what was the facts? Can I just take 30 seconds to explain what happened in Jehovah's Witness case in my own words? With my lord's permission. May I, minutes? So, in the Jehovah's Witness case, the witnesses, or rather the practitioners of that particular denomination, also took an anti-national oath, specifically saying that they will not swear allegiance to the empire of Satan. That was a specific position. Then they also had properties where they would undertake their own discussions to, let's say, give effect to their belief. The government took over that entire building. The court finally said, you can kill the effect, but you can't kill the practice of the belief. Which means you can take the property, but you don't get to say that they can't believe in this. That was the position ultimately that emerged in it. Kindly take a look at para number 16 at page number 10. Now there are 3 ladies who have played a formative role in the formation of fundamental rights across the board. Hansa Mehta, Rajkumari Amrit Kaur, and of course you have Mr. M.R. Masani. Can I request my lords to kindly take a look at the top of page number 10 just for a moment. Please see this. Durga Vaidhi, welcome to that. The right to profess, thank you. The right to profess and practice religion shall not preclude the legislature from enacting laws for the social betterment of people. This is the prototype of 25(2)(b), which again shows, so we can't argue that 25(2)(a) applies to 25(1), but 25(2)(b) applies to everything. That may be a bit of a problem to argue, because if nothing in this article is the preamble to 25(2), that means both portions of 25(2)(a) and (b) apply or don't apply only to 25(1), not to 26. That is the history of this particular provision. Then my lords may come to clauses 16 and 17. Please see, this is on 14th of April 1947. Just above para 17, my lords would see, clause 17 was accepted as is where is. Kindly see what happens to clause 16 again. Same thing. 25.2 retains its position as an explanation to Article 16, which is 25.1. Then kindly come to the next page. I'll request my lords to kindly come to para number 18 for a moment at the bottom of page number 11. 18 is not necessary. We just put para 19. I'm so sorry. My lords may come to para number 19, and this will help my lords also assess the meaning of classes and sections. My lords, Sabarimala has it. Page number 12, at the bottom of it is para number 19.
Yes, please.
Please see this. Notwithstanding any custom or usage or prescription, all Hindus without any distinction of caste or denomination shall have the right of access to and worship in all public Hindu temples, so on and so forth. This is the right of access. Kindly come to the next one. Rules of personal purity and conduct prescribed for admission to and worship in these religious places shall in no way discriminate against or impose any disability on any person on the ground that he belongs to impure or inferior caste or menial class. Which is, can I just elaborate on this? You can say that this is the acharam or the custom of this particular temple, but if you use birth-based restrictions to prevent access or entry, then that will certainly be in the teeth of the law no matter what. And that is what translates to 25.2b. So while I'm not arguing the merits of the Sabarimala case, I'm just giving this by way of illustration that if the temple says because of the deity's Naishtika Brahmacharya character, there are certain proscriptions or prohibitions or restrictions on access to a particular class of people, which has got nothing to do with jati or caste in any way whatsoever, because that class is across castes as far as that restriction is concerned, then it doesn't run afoul of this prohibition. Therefore, I'll build this argument as I go along. Section and class are not to be treated as two different classes altogether. Class has been used consistently across the debate to refer to caste. Section has been used as a cross section within that particular class, or it can go beyond it, but it was always meant to have a caste-based connotation, not gender-based connotation, because if that happens, then religious diversity and rights under 26 can be easily defeated. Because there are temples on both sides, or even institutions on both sides across the board, where prohibition applies to people across genders. So for instance, there is this Article Bhagavati temple in Kerala, where access to men is restricted for specific reasons. I had also given this example in 2018 in the first round. There is a temple in this district called Satabhaya in Odisha, where the priestesses are all of them are Dalits, and there's a reason for it. Apparently, the original Brahmin priest ended up seeing the deity in its unclothed form, and therefore, to atone for it, he decided to hand over the temple to 4 Dalit priestesses, and till date, for the last 400 years, the practice continues. The only time the practice was violated or breached in the recent past, perhaps around 2018-19, was because of rising sea levels. The Shivalingam had to be lifted heavily, or rather it has to be completely bodily lifted, and therefore men were allowed for the limited purpose. So what I'm trying to say is that rights under 25.2b or the enabling power under 25.2b has to be applied in a narrow sense, otherwise the purpose of carving out 26 will be completely defeated. I am not making a policy argument, I am making only a statutory argument in terms of what is the history. I'd only request my lords to kindly come to para number 20 at page number 13 for a moment. Following with the revisions which were proposed as far as clauses 16 and 17, kindly see in explanation 2, please see that is the second intended paragraph. Religious worship was substituted with religious practice. Whereas the Honorable Chief Justice sees that. So here, kindly see this. It says, all persons are equally entitled to freedom of conscience and right freely to so on and so forth, and other provisions of this chapter. And in that explanation 2, which is 25.2, for the words religious worship, practice shall be substituted. Therefore, financial, economic, political, or any other secular activity, previously it was associated with religious worship, it becomes religious practice. Then my lords may come to para number 21 for a moment, where I basically summarize the net result of the discussion on clause 16. Can I request my lords to kindly take a look at para 21 at page number 14.
Practice is broader than religious worship.
I'm so grateful. That was the intent, because otherwise it also limits rights under 25.1. And therefore it was meant to widen up the entire conversation, both under 25.1 and 25.2.
Also it enables the state to make the law.
So grateful. That means
The law then.
I'm so grateful. That means the power of the state is not limited only to aspects of worship. It also extends to practice. I'm with my lady.
No, it doesn't extend to worship. It extends to practice.
Practice. Fair enough.
It is broad enough, but at the same time, it
Text
does not extend to worship to be the.
I stand corrected.
Yes.
Grateful. I'm grateful for the nuance. I didn't think of it that way. I'm grateful for it. Kindly take a look at para 21, and I request my lady to kindly see Romans 1, 2, 3, and 4 for a moment at page number 14. My Lord Justice Kumar has it? Please. The term religious worship was replaced with religious practice in explanation 2. This explains the use of religious practice in 25-2A. Social reforms were made permissible with the consent of, kindly underscore the words, legislature. Which means this addresses one fundamental question across the board. Subject to clause under 25.1, enabling power under 25.2, subject to clause under 26 are powers to be exercised only by the legislature. Is a humble submission that all of that, which is why I think Mr. Gopal Shankaran said it is vertical in that sense, that the restrictions on those rights can be applied only by the state. And the state, my lady is aware, under Article 12 and 13, state does not include the judiciary in its judicial capacity. Mirajkar and several judgments have held to that effect. Therefore, for the purposes of this chapter or this part, the reference to state is to the executive and the legislature, and in my humble submission, it does not include the judiciary. Therefore, the question of entertaining any writ petitions, challenging those practices on the ground that it violates any of those subject to provisions, does not even arise simply because those powers are limited to the state. And this perhaps could answer the question differently. I'm so sorry, my lady has something.
No, if the state, it enables the state to make laws.
Yes.
To bring in social reform.
Correct.
Such as, for example, entry.
Correct.
Now, the question here is not, the controversy is not that the state has banned entry as such.
I understand.
State has made the law, rules, act and the rules
Right.
for entry.
I'm so good.
Under that, because of the customs, there is a prohibition
So can I,
in the Kerala Act and rules.
my lady is correct. So here what I have done.
Made a law banning entry.
Please.
State has made a law promoting entry.
I'm so grateful.
But under the customs,
Yes.
there is under the 3B rule.
Yes.
There it is an exception.
So may I just respond to this? There are two specific portions of my written submission, both the old and the new, where I've specifically addressed this. And can I volunteer to respond to this before I continue with this? Because a question has arisen from the bench. Codification of a pre-existing religious practice by the state does not make that practice amenable to judicial review because it is not exercise of rights under 25.1 or 25.2 where limitations are imposed. The submission is, if judiciary cannot or the courts cannot preside over constitutional challenges to practices themselves per se, merely because the state rolls that practice by way of a legislation, that doesn't make it amenable to review is my humble submission. Because at the core of it, my lady would still be getting into the question of 25.1 and 25.2 in that sense.
In other words, whether the rationality of that custom can be questioned in a court of law.
I'm so grateful, that's the question. And if I may make this humble submission, I'm therefore applying the simple principle that what cannot be done directly can also not be done indirectly. So if you cannot get into the rationality of a religious practice, ipso facto, merely, my apologies.
The basic structure.
May I answer the question?
Yes.
I'm so grateful.
You
And there was.
you can say that what the court is very restrictive.
Yes, I'm grateful.
A better argument.
I'm with my lords on that, which is in the process of entertaining those writ petitions to the challenge, again ERP test cannot be applied, whichever way that route is, which is the rewriting of the rules of religion would be beyond the scope of judicial review under Article 32 and 226 is my humble submission. Since the question of rationality was raised, I think Justice Varali and
Slightly different. But
My
the moment you extend the wing of the state or the executive,
please, please.
the power of judicial review automatically comes.
I'm so
The
grateful.
state in the name of social welfare,
Right.
of course, prohibits the religious practice.
Right.
Who will examine?
I'm so good. Can I answer this question? When the state, I'll just show one thing. Can I request my lords to kindly come to that portion of my written submission where I've answered this question straight off? Can I finish this and come to that next? Just so that the flow is not broken.
That power of judicial review, there is no need to attack on that power so much.
Fair.
That if we understand that limitations are there,
Please.
but to say that there is no power at all, it may also be very difficult to you.
No,
It's
I
a
agree with
hypothetical
you.
situation.
I
It
completely.
will again depend upon
Please.
the situation.
Can I perhaps request my lords to come to page number 27? I'll show this at a later stage where I've addressed this question. Allow me to just complete this
No.
train of thought. Please take a look at this.
Yes.
My lords, I'll take it. My lords may kindly come to para number 21. So social reforms were made permissible. The Kirpan explanation or the exception continues. Explanation 3 was omitted, which was civil obligation on certain religious institutions. Then kindly come to para number 22. In my humble submission, this extract from Shri K.M. Munshi is necessary to understand the purpose of 26. Kindly see this, and I think Dr. Dhawan actually pointed this out. Does the honorable bench have this? Kindly see para number 22. Religious freedom is meaningless if this clause is deleted, which is on clause 17, the equivalent of 26. Fundamental freedom of religion necessarily carries with it the right for a religious denomination to retain property. Which means when denomination was used here, it was not in the sectarian sense, but to say any collection of people exercising their rights under 25(1) would have and would need the right under 26 to give manifestation to that right in an institutional form, to run institutions. Because at the end of the day, that belief also translates to charitable intents, educational intents, religious intents, so on and so forth. Then kindly see, this clause was not objected to by Dr. Ambedkar. He only rephrased it in a slightly different way, which is at the bottom of page number 14. No religious denomination shall be disqualified to manage its own affairs. That would cover the case. That was Dr. Ambedkar's suggestion. Then kindly come to the next page. So Article 17 or 26 was reworded in this fashion, which is extracted on the top of page 15. My lord sees that. This was the entire paragraph. And therefore, my lords, I made the point here that clearly the word religious denomination, there's a typo, it's not word, it's the word, was not meant to be used in a restrictive sense, since it was meant to give effect to religious freedom which was available to everyone. Consequently, the term religious denomination has been used as a synonym for religious association. There are multiple typos here. My apologies for it. This was dictated last evening. Kindly come to para number 23. And my lords would see that on 22nd of April 1947, these were the revised versions. Again, explanation 2 continues with clause 16. Then my lords may come to the next page, page number 16. Page 16 speaks of clause 17. And then my lords may come to para number 24. This is the interim report of the Advisory Committee on Fundamental Rights of 23rd of April 1947 under the chapter Justiciable Fundamental Rights. So clauses 16 and 17 become the new 13, 14. They change numbers multiple times, but the spirit remains the same as my humble submission. My lords may then come to para number 25 on the next page. This addresses the second portion of 25(2)(b). At page number 17, para 25. My Lord Justice Masi has it. Please. The interim report of the Advisory Committee was presented to the Constituent Assembly on 29th of April 1947 by Sri Sardar Vallabhai Patel as the chairman of the committee. When clause 13 was taken up for discussion on 1st of May 1947, again it's Sri K.M. Munshi who proposed to add the words, and for throwing open Hindu religious institutions of a public character, kindly mark the words to any class, it should have been or section of Hindus. Class or section of Hindus. This was meant to be added to explanation 3. So kindly see explanation 3 on the top of the page, where it says, from enacting laws for the purpose of social welfare and reform, to that this portion was meant to be appended and said, and for throwing open. Now please note, class or section have been used as legal synonyms for a specific reason, because they were dealing with the realities of that day. And therefore it always had a caste-based connotation. It's a humble submission. Whether my lords chooses to use the word class or section wouldn't make a difference. Then kindly come to the next page. Sorry, my lords would see. So after the addition of these words, on the next page at page number 18, the new explanation 3, which is Proto 25(2)(b).
25(2)(b).
I'm so grateful. So this is it. This is 25(2)(b). Now, my lords, kindly see. Clause 14 was taken up. 14 was for 26. By now, it becomes 13 and 14, 25 and 26 respectively. So it basically said that all of this will be subject to general law. They just decided to drop the word general and became subject to law. And that subject to law then is appended to 26D at the end of it. It is meant to apply to 26C as well as 26D. My lords may then come to the bottom of page number 18, page number 27. Sorry, para 27. Now, kindly make a note of this. This is when these are all discussions by the drafting committee. After the drafting committee has been appointed on 29th of August 1947, extensive discussions are undertaken. These are discussions by the drafting committee. Now, this, my lords, at the bottom of page number 18 is the provision with respect to 25(1). Kindly come to the next page. No structural change whatsoever. And now my lords would see 25(2)(a) remains as explanation 2 and 25(2)(b) becomes clause 2 of this particular clause. This is the nature of it. This is the entire discussion. Now I request my lords to kindly come to page number 20, para 29. So sorry, kindly take a look at para 28 at page number 18. Insertions have been made with respect to public order and morality in clause 20, which is 25. And then my lords would see, now comes the familiar construction of this language. Nothing in this section shall preclude the state from making any law. A and B have been provided for. So that's 25 to A and 25 to B. On the next page, my lords would see clause number 21, which is the equivalent of 26, which has taken a position or a structure which is almost similar to Article 26 as it stands today. So for my lords, what I have done is I have annexed this entire discussion as annexures A, B, and C to this note. So can I request my lords to kindly come to the index for a moment? I won't walk my lords to the entire document. I'll just show the index. Kindly take a look at it. Annexure B, which is entry number 3 of the index, which is the discussion of 6th of December 1940.
Running page?
Yes, index of this spiral line. Spiral 50.
So running page.
Running page 50. 50 to 86. Kindly make a note of this. This discussion on 6th of December 1948 was a discussion with respect to Article 19 before it became 25. So 19 to 25 as a transition is covered in this entire annexure, 50 to 86. Just so that my lords knows that I have not chosen to selectively. Then annexure C, 7th of December 1948 is on Article 26, which was previously Article 20. So page 87 to 96 covers 26, the earlier avatar being 20. 50 to 86 covers 25, the earlier avatar being 19, just before its adoption. Therefore, I'm just summarizing this conversation for my last consumption at page number 21, para 31. Kindly take a look at it. Does the bench have it? Page number 21, para 31. Please read this. What emerges from the above history is as follows. My Lord Justice Sundaresh has it?
Yes.
Article 25(2) is a limitation only on Article 25(1) and does not extend to Article 26. In my humble submission, an argument to the contrary would be an ahistoric argument. It will be an ahistoric argument with no basis in history if an argument to the contrary is presented, because this is the history of it. Part 3 does not apply to Article 26, is the second summary. Third, religious denomination as used in Article 26 is a reference to any religious association of people held by a common belief. The exalted requirements cast by Shirur Mutt do not apply, and no declaration is needed to enjoy rights under Article 26, since it is seen as a manifestation and corollary of rights under Article 25. Since there is no definition for religious denomination in the Constitution, nor is there a separate identification of rights for non-denominational institutions, it means that Article 26 was meant to cover collective rights of religious associations. Kindly see the last 4 lines. Simply put, Article 26 is another form of 19(1)(c), but applied in a religious context. This is also evident from the similarity and limitations applied to 19(1)(c).
Oh, we understand your argument. The submit of 25(2)(b) will be applicable to the persons, but on the contrary, it not apply to the religious denomination. Right?
Grateful. I'm so grateful. There's one additional point on that. Can I request the bench to kindly take a look at 26?
What if the persons are all members of religious denomination?
I'll just come to that. Kindly take a look at Article 26. I'm making a.
How do you give effect to it?
I'm so sorry.
How do you give effect to it? You're asking. How do you give effect to this? If your argument is accepted.
Please.
You 100% join together.
Please.
And create a religious denomination.
Please.
Your argument. It will apply to 100 of them individually, but it will not apply to the institution.
That's why I wanted to show one nuance from Article 26. Could my lords kindly have the provision before my lords for a moment? This is a middle path.
Yes.
So this is for my lords to consider that denominational rights cannot be elevated to the status of minority rights. That's not necessary. That equation I have to disagree with. And therefore, in that sense,
We take it in so far as the religious denomination are concerned.
please.
There is no question of the application of the social reform or social welfare.
No, I won't make
Because
this.
they're asking because they're putting it so high because we have to ask. Suppose you can't, they cannot go into that line at all.
In fact, my lords, can I make the submission?
Yes.
On the position that Article 17 has become part of the corpus of public morality, I am entirely with Mr. Gopal Shankar Narayanan. That question cannot be run away from under any circumstances. The second point for my lords to consider is, kindly take a look at Article 26 just for a moment along with me. It is not as if 26 has no limitations whatsoever. It is not as if the state has no power whatsoever with respect to rights under 26. So there are two approaches. I'd only request my lords to kindly be patient with me because I'm building two arguments which will address my lord's question. One, public order, morality and health literally are, in my humble submission, are like Akshay Patras. They are so broad and huge and wide enough that any concern that the state may have with respect to, let's say, some kind of social justice reform is capable of being accommodated within 26 without having to come through 25(2). And this is retaining the consistency of the argument, which is 26 need not be affected by 25(2). That does not. I'm sorry.
Constitutional limitation under 25(1). 26, it limits your right to practice, profess, and then it is subject to public order.
I'll come to that.
To that extent, you can say public order or the morality and health, so far as your right to administer and manage a property, to that extent it will come.
I'm grateful. So can I just request my lords to take a look at
You can't say piecemeal, you can go into the other thing, you can go to the
my lords is 100% right on that, which is why let me not join issue with my lords on the point. Let me just explain where I'm coming from on this point. My point is 26A, B, C, and D. So a denomination has rights both under 25 and 26. It's not as if denomination does not have rights under 25. Because it says person. State Trading Corporation 6-1 judgment of this Honorable Court clearly says person includes a body of people, body corporate, including companies for that matter. Because a distinction has been struck between citizen and person. Second, rights under 25(1) of the denomination are different from the rights of the very same denomination under 26. So what I'm trying to submit is 25 addresses a different basket of rights. 26 addresses a different basket of rights of the very same denomination. Which means, kindly take a look at A, B, C, and D. Let me just explain this argument from my perspective.
One way, before you do that, 26B is in matters of religion.
I'm so grateful.
But 25(2)B is with regard to social welfare and reform.
I'm grateful. That's the point.
The distinction
Has to be drawn. Therefore, I'm trying to make the submission
in
that
the guise of making social welfare or reform
can't affect 26B.
can't encroach upon matters of religion.
I'm so grateful. So my submission would be, kindly think of religious denomination as this branch which enjoys two sets of rights. One set of rights falls under 25(1), another set of rights falls under 26. You can certainly affect 25(1) rights because that's what 25(2) permits. But in the garb of doing so, you will not venture into the realm of 26 because there are only three permissible lenses permitted for 26: morality, order, and health.
What Dr. Singhi also
I am grateful. The difference is Dr. Singhvi's argument connects 25(2) with 26. I am saying you don't need to go down that path as far as 26 is concerned, because if you can delineate the scope of rights between 25 and 26, this neither here nor there argument, my apologies, I have to use the biblical term dog in the manger, that argument cannot be used, or that kind of an approach cannot be had where you sail in both boats. In my humble submission,
you will require judicial review then. You'll have to come to court to say my right under 26B is affected.
Please.
In the garb of making
25.
it now under 25(2)B.
I'm so grateful.
Then you have to come to court.
I have to come to court. Therefore,
But
I agree. State action is amenable to judicial review. I stand by that position. That's what my written submission says as much. In any way. In fact, I have some answers even to the questions that were raised by the other members of the bench. Let me just answer this question.
So, Mr. Deepak,
Please, ma'am, please.
if this interpretation is accepted,
Please.
that the affairs relating to matters of religion
Yes.
and the right to profess, practice, propagate religion
Yes.
are basically a subset, affairs of religion in the bigger set of rights.
In the universal sense.
So, you yield to the argument essential religious practice is what is relatable to 26B, whereas other religious activities are more generic and is 25.
I have a slightly different approach to it. Can I request my lords to kindly indulge this argument? I could be wrong, but I'll nevertheless let me canvass and ventilate what I think is the position.
Because you are now diverting from 25 to A, secular activity,
I get it.
religious activity, complete different
I'm with my-
notes. You are mirroring 26B
Right.
against the bigger canvas of 25(1).
Please.
And in this situation, whenever a social reform legislation comes into being,
Please.
or whenever any exercise is undertaken to test
Right.
the matters of religion under 25B,
Right.
the court will be entitled to look into the essentiality, or as it is said, integrality, so that there is no hollowing out of that religion.
I'm so grateful.
This is one.
Please, I'm so-
Secondly, let's also consider the interesting difference after Dr. Ambedkar
Yes.
brought in the idea of association, religious association.
Please.
The word association was not used,
Correct.
but denomination was used
Yes.
in inspiration from Article 44 of the Irish Constitution.
Please.
So denomination needs to be given a more contextual interpretation than association under 1916.
Can I respond in the reverse order in the way the questions have been put? Because I think it's the easiest from my own memory. Please consider this. The comparison with Article 44 of the Irish Constitution, and I think we have actually discussed this so that this argument can be presented. The Irish Constitution recognizes the existence of God. It is not a secular constitution. It's the first submission. Second, Irish Constitution effectively treats denomination as a congregation, because every congregation is a denomination within that particular legislation. Therefore, no exalted standards are sought to be met or imposed or cast as far as Article 44 of the Irish Constitution is concerned. The surprising part is, by the time denomination it travels from Ireland to India, denomination suddenly becomes a higher right, which is not the case, because the anomaly it will create is denominational institutions are somehow great. They enjoy greater protection with respect to state compared to non-denominational institutions. That would militate Article 14, which is to say that we can't interpret this in such a way, and that is perhaps where my disagreement comes with Mr. Shankar Narayan on that issue, that denominational institutions, if they're elevated to such a status that non-denominational institutions are practically seen as destitutes as far as constitutional rights are concerned, that's a violation of Article 14.
Sir,
If I may.
the non-denominational institutions are enjoying Article 25(1) right.
But they won't get the same protection as 26.
Absolutely, because
It is why the
there is a reasonable classification with regard to a greater commonality in denomination institution than the diffuse nature of a non-denomination religious activity.
I understand where my Lord's argument is coming from, but I'm unable to convince myself because of the peculiar history of the Irish Constitution, because they've used the word denomination as a synonym for congregation across the world.
I follow your
Great, so Deepak.
Irish Constitution.
So that's one, my Lords.
Mr. Sai Deepak,
My Lords, kindly give me just 10 more minutes. I'll try to wrap it up in 10 minutes.
I was already 15 minutes.
No, I understand. My Lords, I have not repeated anything so far, that much is clear.
But you need to not
I'll rush.
so much.
I'll just rush it. So I'm only making the submission that the easier way would be threefold in terms of the lucidity of the proposition. Kindly don't elevate denomination to an exalted standard. Separate the set of rights between 25 and 26. Thereby, state has rights with respect to 25 rights as well as 26 rights. The only difference is 26 rights will be governed by 26 and 25 rights will be governed by 25 too. That is the limited submission I'm trying to make. And this in no way will do injustice either to the language. In fact, in my humble submission, it will be completely consistent with the history of the provision. Because I haven't seen anyone present an argument to say, when the constitution framers, mothers and fathers and everybody else decided to use the word religious denomination, they meant this exalted standard. There is no such document to this effect. Which is why I annexed all those annexures.